So good afternoon, everyone. I've got the elusive half hour of dual time for ethics, and want to thank Jared Word and thank Barbara Moss and all the other presenters for putting this on today and putting a great program on. Also want to thank Donna Harkness for helping out with a lot of materials in the past. I know I've kind of reviewed a lot of what she put together in the past because she's been a wonderful presenter for elder law ethics. Also want to thank Laura Chastain, who taught me everything about ethics, and Arthur Cook presented a wonderful conflicts of interest presentation at the Probate and Estate Planning Forum about a month ago. So a lot of great materials out there, and I am glad to present today. I consider a lot of what our ethical considerations to be are just simply forecasting future issues. How do we protect our clients? How do we protect ourselves? I find that nearly anytime we're working in an elder law matter, certainly, especially in estate planning, you have multiple rules that you're dealing with at any given time. Um, you've got several rules coming into play on just about every single time that you're meeting with someone. What are you going to do for them? What's your scope of representation? How are you going to communicate with them? Does it conflict with representation for someone else? Often enough, you'll find that you're dealing with clients with diminished capacity. They're bringing you, I find usually I'm getting folks wanting me to revise or amend some of their estate planning documents, and I always end up in possession of their originals. I think everyone needs to have a good office policy for how do they deal with originals, and also how do they build their time and how do they bill appropriately. So the first rule, I think we all know whenever we're taking on new work is, do we actually know what we're doing? Rule 1.1 is for competence. We all need to provide competent representation for our clients. And this requires a certain amount of knowledge, skill, thoroughness, and preparation for us to be able to take on that kind of representation. I find the prep work is usually where I'm spending the most of my time. Of course, we all bone up on our knowledge and skill through these great CLEs like this. And being a thorough, I think, is part of being a great attorney is just probing for answers and probing for better answers at all times. But even if you feel like you're a fish out of the water, comment two to rule 1.1 provides a good encouraging tone there that determining what you need to do and what kind of legal problem you're going to encounter. And the comment says that transcends any particular specialized knowledge. You can provide adequate representation in a whole new field through necessary study. Competent representation can be provided through the association of another attorney. And there's fantastic attorneys in our elder law section for the TBA, and everyone is really happy to lend a hand as necessary. I find with a lot of my matters, they seem to be kind of driven by statutes or by TennCare manuals, and most of the information that you need is available to you if you know where to go and find it. And of course, if you don't know where to go and find it, that's where you might associate another attorney to help you get in the right direction. AI seems to be at the forefront of everything that I'm seeing these days. It's in every CLE that we present at and that I attend just about. I find that many people are using AI as a substitute for actually doing their own legwork. I think it's a good place to start for some of your research, but by no means should it be the end. You'll find fabricated cases as often enough. And so I think it's always good to be thorough, be prepared, and double check what you're doing, double check your work there. So once you know what you're doing, you need to know who do you represent. And I think you need to make sure everyone knows who you work for and who you don't. If you've got an elderly individual coming to you, sometimes they'll come by themselves, sometimes they'll bring their family. Are they acting in a fiduciary capacity as an executor or an agent under a power of attorney? Are they merely a beneficiary under an estate or a trust? I find for many of my clients, they lean on their family members quite heavily to help them uh, as 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 minimal as just helping drive them to an appointment with me. Some of it's a bit more involved, dealing with someone's finances or helping them make decisions. I find sometimes I have clients that won't make a decision on their own. They'll turn to their son or daughter or their fiance of 2 months and say, well, what do you think? And kind of supplant their own decision making and let someone else kind of tell them what to do. So I think we've always got to have our antenna up as good elder law attorneys to know what we need to look for. And when possible, obviously find out early on who do you represent and make sure everyone knows this is who I'm working for, this is who I'm not. Meet with them separately and maybe have, to the extent that your representation allows and to the extent that your client's giving you informed consent, confirmed in writing, maybe have a joint session with the family and tell everyone, here's what we're doing. With my client's permission, I'm going to tell you, what's going on, or have everyone come to you and tell you what's going on, and then maybe kick everyone out and get right back down to, all right, I got to meet with my client. But at all times, you need to know who are you working for. And that's going to get into conflicts in a moment, but I want to camp out on scope of representation. Often enough, you'll find that you've got a elder that wants, the family to kind of lean in and help make some of those decisions. If the client wants their spouse or child or whoever to sit in on a meeting with you, Rule 1.2 says that we need to abide by that decision concerning those objectives and consult with them by which we're going to pursue those means. We can limit scope if it's reasonable under the circumstances and if we have informed consent. I find myself more and more being asked tax questions that I know the answer to, but I also don't feel necessarily competent to provide too much tax advice in too many scenarios where I need to do it. I think I can limit my scope of representation, so I don't really do tax advice. I'm a great attorney. I'm a lousy accountant. Let's get your CPA or mine involved to answer some of those questions. Sometimes you might say, hey, I'll help you out on a Medicaid application and with some Medicaid planning, but I'm not going to necessarily do the appeal. I might turn you over to someone else for that. So you can always limit the scope of your representation, but you also need to know where your bumpers are for what you're doing with your client and making sure that you're abiding by those decisions. So we reference Rule 1.4 in here for communication. This is the only highlight I have in my bland PowerPoint here, but it is that we need to be able to explain to the extent reasonably necessary to allow our clients to make informed decisions regarding any given potential outcome. I find myself long-winded at times to tell folks these are pros and cons. Now, I think if a client's going to take any proposed course of action, they need to know the drawbacks, they need to know the advantages, they need to know the financial considerations for a given course of action and the timeline. I think that's just what we need to do as attorneys and what best practice would be. But we need to promptly inform them of any decision or circumstance with respect to which they need to give us informed consent. We need to reasonably consult with the client about the means by which their objectives are to be accomplished, keep them informed on the status of a matter, reply with reasonable requests for information, and consider any limitation on our conduct when you may have a client asking you to do something that you can't do in accordance with the rules of professional conduct or with other law. I don't find that I encounter that too much in my elder law practice or my estate planning probate practice. I do find that a bit more in the family law world. But obviously, if someone's asking you to do something you can't do, you need to make sure that they are aware that, hey, I can't do that. You need to make sure that they're well informed on anything going on. Um, Often enough, if you're planning on something and you need more information, let them know that. If it's going to be a while before you can meet with them again, sometimes just a simple, hey, not today, but I'll talk to you tomorrow will suffice. But more than anything else, I think if you look at all the when they release the roles for all the ethics complaints that we get each year, I think communication is one of the biggest issues across the board, across the state. And I think it's hard where everyone demands that we reply to them immediately. And sometimes you'll have a client email you every day on a matter. And, I think having good communication, effective communication, is critical for all of us to make sure that clients know when a deadline is, or when we're going to let them know what to expect, or if we've received some paperwork back from someone. I have plenty of out-of-state clients with matters local to Tennessee, and I find I'm always waiting on the mailman to come by to bring something to us. I think just keeping clients abreast of what's going on is critical for us, as you all well know. Rule 1.6, confidentiality. I think this goes right back to who do you represent. If you've got a child or an heir or a devisee, asking for some information, you need to double check what information you can provide and what information you can't. Often enough, I'll meet with an elder and say, "Oh, I trust Junior. You could tell them anything. Tell them anything you need to say to me. You can say to them." And I say, "Okay, let's make sure that we can affirm that in writing, and that I can always point back to that if that changes." And of course, the clients are allowed to change their mind, and they may have a falling out with Junior, at which point you have a falling out with Junior, and you can't give that information to the family anymore. But as long as they give informed consent to reveal information, or if it's impliedly authorized in order to carry out your representation, feel free to disclose. But you always need to be careful with how do you accomplish your client's objectives. Often enough, if you need to tell, a child, hey, I need you to bring dad by, here's what's going on, because dad's not driving, bring dad to the office. I find that to be impliedly authorized in order to carry out the representation, but there's only so much you may reveal there. And of course, you may want to say, I really can't tell you that much, son or daughter, but I can get your parents here and we can speak about that. And then to the extent that they allow me, I can then reveal that information as well. I find one thing that constantly is kind of a burr in my saddle is when I'll be on the phone with a client and we'll have a whole conversation. And then towards the end, a voice that you haven't heard the entire conversation over 30 minutes says, "Hey, I got a question." And you wonder, well, who the heck is this? I think you always need to be careful and considerate of being aware of who is within the earshot for phone calls. I really try to do in-person stuff as much as I can, but of course, we email folks with phone calls all the time. Sometimes you just can't get people face to face. Certainly, with a busy practice, your FaceTime, so to speak, is probably your most precious asset. So where you can, make sure that you're taking time to slow down and meet with folks. But where you don't have the time, or someone's tech savvy enough, make sure that you can be efficient and effective for them as well. Moving on to conflicts of interest. Of course, this is really going back again to who do you represent. You can't take representation that involves a concurrent conflict of interest. I think the textbook example for most of us is if we represent a married couple, we need to make sure that that is addressed and make sure that everyone's aware of that. But obviously, we all know these rules. You can't represent one client directly adverse to another, or if there's going to be a significant risk that representing one is going to limit you in your responsibilities to another, or to a former client, or to a third person, or by personal interest to you. I try not to really get involved too much in friends and family issues apart from something benign or simple there. But I do find, if you are representing co-trustees or co-executors or co-agents under a power of attorney, oftentimes you will encounter a significant risk that your representation to one is going to be limited by your representation to the other. If you've got a trustee that says let's go left and the co-trustee says let's go right, are you stuck at that fork in the road until one of them caves, or do you need to withdraw because you've got a conflict of interest? I think you've got to be able to line that out and have it well laid out in your engagement agreement. Continuing on down, we can still represent clients as long as as long as it's not prohibited by law, and as long as we think we can actually take this on. And we've got informed consent confirmed in writing from everyone. Conflict waivers are pretty routine in my practice to make sure everyone is aware of what I can do, what I can't do, and what it means if we encounter a conflict where we can't overcome this. We're stuck here. I'm going to have to withdraw, and you'll each have to get your own attorneys potentially. Of course, we certainly don't want to get in bed on any kind of representation where we're asserting a claim by one client against another in the same litigation. That's just kind of obvious. So back to dual representation. Often enough, you'll find a married couple wants you to work on their estate plan. They want a will, they want a trust, they want you to help out. Or maybe you've got two siblings against another sibling in a will contest or in a partition case where everyone's inherited some real estate. What's that going to require of you? You need to make sure that, again, everyone knows who you represent and who you don't. And be specific. In our engagement agreements, we'll say Mr. So-and-so in his capacity as executor, or Mrs. So-and-so in her capacity as the conservator for her mother. We'll be real granular with how we're addressing that. But I think it's best practice for everyone that you have a well-drafted engagement agreement that addresses how you'll handle confidentiality, and probably spell out that there's not going to necessarily be confidentiality between two clients in a dual representation role, that everyone needs to be on the same page and that we can't have any real conflicts or disagreements. So again, if one of you wants to turn left and one of you wants to turn right, I'm kind of stuck in the middle until we resolve this. And it may be that I need to withdraw and let each of you get your own attorneys, and that may bring everything to a grinding halt. But that's part of why you want to address that on the front end, is to make sure that everyone is going into this with their eyes wide open when you're at the outset of your representation. One thing that I have seen multiple presentations on here recently is the question of, should you act as a fiduciary? Rule 1.8c says that we're not supposed to solicit a gift, including a testamentary gift, or prepare an instrument to give us any substantial gift, unless it's family. But you're not supposed to be soliciting this kind of role. I think you can act as a fiduciary and act as a trustee or an executor or a agent under a power of attorney or a conservator if you've got informed consent and everyone knows, hey, this is an opportunity for me to make some money again. And obviously this needs to be plan Z, not plan A. You shouldn't be soliciting this necessarily and kind of making that your first offer. It needs to be really where you've got an elder that doesn't have anyone else who can step up to the plate, or obviously if it's by court appointment. If you're getting appointed as a conservator, well, then you better act as a fiduciary because the judge wants you to. Accepting payments from third parties. I think we find this often enough in our practice where you'll have an older individual whose child is kind of managing their affairs for them, whether out of necessity or convenience. And the rules called, that's okay as long as the client, that your older person who's going to be the person you work for, gives you informed consent. And of course, that needs to be confirmed in writing, that there's not going to be an interference with your independence or with your attorney-client relationship, and that you're protecting confidentiality. Probably want to make sure that child or caregiver who's managing the bank account understands that we appreciate your money, appreciate you taking care of this invoice promptly, but I still can't tell you anything, and you still can't run the show. You don't dictate what's going on. And I've had someone look me in the face before and said, "Well, I'm writing the check, so you're going to tell me what's going on, and you're going to tell me everything." And I said, respectfully, ma'am, I can't do that. If your parent is cool with that and wants me to tell you what's going on, I'll certainly be a bit more open to conversation. But I've got to protect your parents' interests, and I've got to protect their confidentiality. Now, once that parent says that's fine, I think that's okay. But if not, then it's a hard conversation, and sometimes you just have to lean into hard conversations in what we're doing. I think we're all a real friendly bunch in the elder law section. I think we don't have a lot of adversarial proceedings quite as much as you might see in a family law setting, for example, or in a divorce. And I think you can be very collegial and very friendly. Certainly, that's what I've found in our section. But I think everyone is also happy to lean into a hard conversation or a difficult conversation with a client or opposing counsel. And sometimes I think you just need to be able to put your foot down and make sure that everything is ethically compliant, both for yourself and for your client. So Rule 1.14, capacity, I think this is one of the bigger rules of ethic that's relevant to the practice in elder law, because sometimes it's hard to maintain that normal client-lawyer relationship with the client, where we're all used to being in front of our computers. We email all the time. We'll send a voice memo. We'll have a voicemail. You'll have clients who, hey, I'm not really a big email guy. I'm not tech savvy. If you need me, call me. I don't pick up the phone because I get spam calls all the time. If you leave me a voicemail, maybe I'll check it at some point this week. If you text me, maybe I'll know how to get that text and text you back. But sometimes you just have to slow down and try to maintain as much normalcy as possible, and kind of get down on your client's level sometimes. The rules in 1.14 says that we need to take reasonable, necessary protective action, which can also involve consulting with others that have the ability to take action to protect the client. And in appropriate cases, you can seek appointment of a guardian ad litem or a conservator or a guardian. And I know Amy just gave a wonderful presentation on conservatorships. If you think your client is at risk of being taken advantage of from a scam from one of these TBI scams, where the TBI is looking over everyone's shoulders to make sure that that's well addressed, you might need to file a conservatorship, and Rule 1.14 provides for that. Of course, a conservatorship is supposed to be the least restrictive means necessary, and I think to the extent that you can exhaust all other remedies, you might consider consulting with other individuals or other entities to make sure that, to the extent you need to, that you can take care of your client. And this may involve consulting with a son or a daughter or other family members, or with a caregiver that's taking your elderly client to and from meetings. You might need to, as you're walking out, hey, by the way, we've got another consultation, we've got another meeting here in 2 weeks. Make sure that's on the calendar, and you're going to want to do that. If there is a scam, you're going to want to take appropriate action. You might be filing an emergency conservatorship And you might go back to Rule 1.1 and say, I don't know anything about a conservatorship. You can call Amy, you can call me, you can call anyone and kind of um, get the skinny on what you need to know about that kind of stuff. Um, because that's what's demanded of us in our rules of ethics is that we take the appropriate action to protect them from scams or from attacks from within. You may have someone pilfering an elderly person's finances there, which is becoming more and more prevalent. So I think we all need to be hawk-eyed and sharp on what's going on there. And that kind of leads into my next slide of the need for us to be vigilant. You want to look at your client and look at, how are they looking from one appointment to the next? What's their hygiene look like? Are they having difficulty communicating their wishes to you? Do they just say, well, we'll figure that out later? You might have to lean into another hard conversation and say, well, let's talk about that. What's your hesitation there? What's the fear in taking one course of action or another? One big red flag for me, which can be easily explained sometimes, is that you'll have a child caregiver that's maybe not working and living with the parent, or are they too close? I think that's just your textbook example of maybe getting too close to the finances for someone, and it may be that is a natural consequence under the circumstances of of course I'm living with mom or dad. I've always taken care of them, and I would do anything for my parents. And I think many of us would say I would do anything for my parents. Of course I'll live there. Of course I'll take off work. Of course I'll help out. But it does open the door to potentially, maybe you've got a child that's wasn't jointly on the bank account and they put themselves on the bank account, whereas maybe they could have had a well-drafted power of attorney and separated ownership from decision-making authority, and maybe that would have been a better way to handle that. But I think we always need to be vigilant for elder abuse, financial abuse, and just if something doesn't pass the sniff test, so to speak. And I kind of just covered this of separating ownership from authority. Glenn had a wonderful presentation on POAs and how, sometimes that is the most critical legal instrument that an individual may have. Of course, you always want to look at whether we've got multiple children. Is someone stepping on the other's toes? Is someone local? Are we making someone in Argentina your healthcare agent when you've got another child or another trusted family member nearby? Is that relative or friend in Argentina really going to be able to help out in an emergency much? Maybe so, but you might consider, who's around. And just have fun with it. Talk about the family relationships and talk about the dynamics there and why someone's close with one family member and maybe not so close with the other. Certainly you don't want to pry, but I think, again, lean into some of those difficult conversations there. And I know I'm running up on time here. Safekeeping property. Like I said, I always find people want to give me originals. I kind of chafe at the idea because that's real finite. I like to have digital copies of everything and let a lot of my folks keep their originals. But of course, we've got a safe. We've got a lot of redundancies there to make sure if we do have an original, there's no way it's getting lost and it's going to be fireproof, waterproof, take care of that stuff. But the rules really for 1.15 safekeeping property are really talking about fees. When is your fee earned? When is it not earned? Does it go into your trust account, your IOLTA, or is it earned on receipts to where it's going to go in your operating account? I think you need to line out your fee structure in your engagement agreement and make sure that your client is aware of that. The rules say we need to be depositing legal fees and expenses into our trust account that have been paid in advance and only to be withdrawn or transferred over to your operating account once they are earned or those expenses are incurred. And that's just kind of accounting 101 for attorneys, is make sure that you've got that taken care of. I know that we all know that. prospective clients, of course, you need to be aware of your duty to folks when you just have a consultation and nothing really develops. You didn't take the next step. You still owe them an obligation to the extent that they think you owe them an obligation, and you still owe them a duty of confidentiality. Running out on time here, I know. Take time to understand. Some appointments I will have them run for an hour. If I've got someone particularly older that I know it's going to take a little bit more time, I'll budget out more time on my calendar. But listen, take time to understand and lean into those difficult conversations. I think I've got no time left. So it is 3:45. Thank you all for your time. I'm pretty easy to get in touch with. And I appreciate everyone's time today. Hope you learned something.